So now I'm just going to look at what the tribunal will look at when they're interpreting the terms of the lease. And they need to interpret the terms of the lease to decide whether the costs are recoverable by the tenant. So the Court of Appeal upheld the first tier tribunal's decision on whether certain works amounted to repair within the service charge clause of the lease in R on the application of Sinclair Gardens Investments Limited v Lands Tribunal, which reinforced that the first tier tribunal does have jurisdiction to interpret the lease. However, having said that, the provisions of Section 27A that allow the first tier tribunal to interpret the provisions of the lease do not give them the right to override lease terms, such as when payment is to be made. So in the case of Southend-on-Sea Borough Council, the SCIGs, it was held that the first tier tribunal had no power to give tenants more time to pay than it says in the lease provisions. Now, as I touched on earlier, there can be a transfer of a case. And if a tenant issues in the court, Section 176A of the Common Law Reform Act 2002 empowers any court to transfer a case to the appropriate tribunal where their matters fall within the tribunal's jurisdiction. However, one thing to note is that if a case is transferred to determine a particular issue, only that issue should be determined by the tribunal. And in the case of Lennon v Grounds Rent Regisport Limited, which is 2011, it was ordered that a case that involved service charges was to be transferred to the first tier tribunal only in respect of the reasonableness of those service charges. Now, the tribunal got that transfer, and instead of just looking at the reasonableness, they decided other matters as well. And the upper tribunal ruled that the tribunal had no jurisdiction to do so under the terms of the transfer.